a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello to all of you watching us today. You're welcome to today's program, Hanging Out with BWF Solicitors. I hope you are all good and enjoying the day. As usual, we promise you will come your way again this Saturday. And, we are here. We fulfilled our promise. And as usual, BWF Solicitors is one of the number one is the number one solicitor, immigration law firm in London. They've won so many awards, and some of their specialities are immigration and nationality, Ghana law and practice, family law, dispute resolution. If you have any queries in these specialist areas that BWF solicitors deals in, I think they do more than what I've mentioned. Make sure you contact them on 0208 493 7340, 0208 493 7340. At the end of this program, Lawyer Eunice, my guest, will also give you their details with the address. Today's topic is how you can apply under the EU settlement scheme so that you can continue living with your EU citizen children in the UK. And my usual guest is Lawyer Eunice Achampong, a solicitor and also a partner at BWF Solicitors. If you want to contribute to the program, you can do so on all our social media handles, especially Facebook and YouTube. Send in your questions, and I'll be able to pass it on to Lawyer Eunice to answer those questions. If you have any comments as well, I will acknowledge it accordingly. Laura Eunice, you're welcome to today's program.
Thank you so much, Vicky. How are you doing?
I'm fine. Looking forward to today as usual. And
That's
how's your week been? And any updates for us?
Yes, so as you can see, it's bright and sunny. So we thank God for another sunny week. I think that everybody is looking forward to more sunshine, which is also a good thing. So I think that we should all be grateful to God that now we have more of the sun. Hopefully, very soon the summer will be here and we can all go out to the beaches and other places that we would love to go to. Um, my auntie in Ghana celebrates her birthday on the Saturday, this
Oh,
Saturday, the
happy
19th.
birthday.
So I am wishing her a very, very happy birthday and for God to continue to honor her with more healthy years, to honor her with more grace, to honor her with the wisdom and knowledge from above and with his understanding. So we pray for God to continue to keep her as she grows gracefully. And I have a friend who is also celebrating her birthday as well. So I am wishing her a happy, happy birthday and for God to continue to sustain her, for God to give her his joy. I mean, his joy, his peace, and his love. So, wishing them both a very, very, very happy birthday. So,
Mm,
I know you are looking forward to the updates, and every week,
yes.
I mean, we are
Mm,
never short of
very important.
updates. So this week we had the Home Office introduce their new statement of changes, and so every time they want to make changes to the immigration rules, they release their statement of changes as to the things that they would like to change within the immigration rules and what it's poignant is that they're trying to simplify things, and so there are a number of changes within their statement of changes. It's over 200 pages, but I'm just going to focus on a few uh, for
And we are not
today.
going to leave this show anytime soon. It has to be about 2, 3 hours show, isn't it?
It would be a long one if we had to
I love
explain
one.
everything in that statement of changes, but just
Mm,
for our viewers, we want to point out what is relevant to them, and then in the course of the coming weeks, if we find out that there's more that they need to know, we will definitely inform them and let them know as well. So this is just a snippet of what
right.
it entails. So in regards to our students, and I'm very happy that they have said that if you are applying as a student onto the graduate route or you are applying onto the skilled worker route, you can put in your application and start work as soon as possible. You do not have to wait for a
Okay.
decision to be made on your application
Mm,
before you start work. So most of the time we know that once your visa is about to expire, you have to make the application quickly and then wait for a decision before you do work and do what you have to do. But it's great
mm,
that you don't have to wait for a decision. You can just straight away start working. And I think it simplifies things a lot for those that are students. And I'm sure they are looking forward to getting onto their graduate route and the skilled worker route, whichever they are applying for.
mhm,
And we also have those that have made applications under the private life route. So let's say um, you are when you were born in this country, you have now lived in this country for a continuous period of 7 years, and you would like to make an application, or your parents would like to make an application to say that they are responsible for you. And
mm,
because the child by himself or herself has formed private life under paragraph 276, they are saying that they have formed roots and ties in the UK. So their
mm,
social ties, their cultural ties, even the language that they speak is all based in the UK. And so they do not have any other ties or family elsewhere. And the UK is the only home that they know. And so when applications are being made for children that are 7, it is mainly based on their private life. And it's good to know that the Home Secretary, who is Mr. Kevin Foster,
mm,
he's the UK Visas and Immigration Minister. Apart from the Secretary of State for the Home Department, Priti Patel, she has a team of people around her
mm,
that help in formulating the immigration rules. And so they have said that if a child was born in the UK and they are making this application based on their private life, they can
mm,
apply for settlement, and
mm,
that is indefinite leave to remain. And so that is something that I think that is a good thing in terms of children who have lived here for that 7 year period and are looking to have their stay regularized in the UK. When it comes to even children who have lived here half of their life. So you usually will have that if a child is usually 18 or between the age of 18 to 25, and they can show that they've lived in the UK for half of their life,
mm,
then they too can make an application based on their private life. So, if for instance a child came here when they were 9 and they have now turned 20, because they've lived here for more than 9 years, that is more than half of their life. And so,
mm.
that in itself is an application for private life because you are showing that you have built deep roots here in the UK, you have
Yeah.
formed the social ties, you have also become culturally inclined to things in the UK. And so that application based on your private life is something that they also deem to show that you are now saying you want to integrate and regularize your stay. So
Mm,
what happens is that usually when an application is made, you are given 2.5 years. And they're saying that if you can show that you have made this application for a 5 year period, which usually would be a 10-year period, because most of the
mm,
time when you make an application based on your private life, you would have had to live here for 10 years continuously before you can make an application for indefinite leave to remain. But
man,
if
yeah.
you show that you have lived here for that 5 year period and you apply under this new settlement scheme, and of course the application is valid and you meet all of the requirements, then they will grant you indefinite leave to remain, which is
Mm,
fantastic for
mm,
children who are making applications under the private life route. So
mm,
that is good news for children who are 7 or children who are making applications based on half of their life here in the
mm,
UK. Fantastic news. And we also have those that are saying that they are making an English language test because maybe they are switching from the 10-year route to the 5 year route. So, usually under Appendix FM, when you're making an application as a parent or as a partner, those applications are said to be family life applications. And so if you're making those applications and you don't meet a certain requirement and the exceptions apply, then they would say that you will be put on the 10-year route.
mm,
However, if you do meet all of the requirements, such as the relationship requirement, the immigration status requirement, the English language requirement, which I am talking about, and the maintenance and accommodation, then you will be put onto the 5 year route. So for
okay.
those who have lived in the UK, have done GCSEs in English, maths, and the rest, or have done A levels, or have done a Scottish equivalent or
Mm,
higher qualification, those people do not have to take an English language listening and speaking test, because most of the time we know that if you have an undergraduate degree, then you don't have to do the ESOL test.
Yeah,
But
you
now
don't.
instead, if you have a GCSE in English and any other subjects, and of course an A level or Scottish equivalent or even higher qualification, then
Mm,
you can use that certificate instead of taking an ESOL test. So that is also another thing that is good to know. And lastly, and not the least, in regards to our EEA family permit applications that were set to no longer be valid from the 30th of June 2021, a lot of these changes obviously took place when we obviously protested against the fact that the Home Office cannot just say because the EEA route has ended, so they will no longer issue permits to family members who have already applied and need to enter the UK after the 30th of June. And so I think that the protest helped, and they finally decided to give family members a family permit under the EU settlement scheme instead of the EA route. And
good.
so if you are somebody who has made such an application prior to the 30th of June 2021 for a family member to come to the
Mm,
UK, and it was an family permit application, be rest assured that the concession that they gave has now been put into the immigration rules, such that those family members can now enter the UK with an EUSS, which is an EU settlement scheme family permit. And
mm,
if those people were to have made the application under the EU settlement scheme, they want to know that those people would also have met the suitability requirements. That means that they are not people who are deemed to have a deportation order or have an exclusion order. And so it's good that it's now been put into the law so that caseworkers are readily available to issue those family permits to those family members that are looking to join their EA national family here in the UK. So that change will take effect from June of this year.
okay.
I know that most of the changes that they have implemented or want to implement will take effect from the 6th of April. So they gradually want people to get used to what they want to bring about. And then on
Mm,
the 6th of April 2022, most of these changes will take effect. Some
okay.
will take effect from May, and some will take effect from June of this year. So, yeah, we will look forward to all those changes being brought into force later
Mm,
this year.
mm, Thank you so much, Laura Eunice. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, your Saturday immigration education program. You can send in your questions and send in your comments as well on all our social media handles, especially Facebook and YouTube, where we are transmitting live. Today's topic is how you can apply under the EU settlement scheme so that you can continue living with your EU citizens' children in the UK. And with me is lawyer Eunice Champong, solicitor and also partner at BWF Solicitors. Lawyer Eunice, regarding today's topic, I just want to find out who the primary carer of a child who is an EU national.
Okay, so I wanted to talk about this because I know there are quite a few people
Mm,
who may have EU national children. And apart from applying under Appendix FM, so
Mm,
under our normal immigration rules, where you apply as a parent of a child, um, it could be a British child or an EU national child, depending on when the relationship was formed. So, this topic is to do with those who have EU national children and they have
mm,
lived there for some time, or they came to live in the UK before the 31st of December 2020. So, I would like to make people be aware that the topic is mainly to do with those parents who came before the 31st of December 2020 and had these EU national children here with them when they came, or had them when they arrived here
mm,
in the
mm,
UK. So, in relation to the EU settlement scheme and who a primary carer is, um, it is not something new because we are deriving all of this from our previous immigration EEA regulation 2016, and prior to 2016 there was the 2006 regulations, and we obviously were bound to EU treaties and directives and regulations when we were part of the EU. And
mm,
because, of course, the UK and the EU had to come to some form of agreement after we left, we decided, or the government of the UK decided, to now implement the withdrawal agreement such that EU nationals and their family members will be
mm,
protected even though the UK is no longer part of the EU. So it's fantastic that those family members will still be able to derive their rights from their children who are EU nationals whilst living in the UK. As long as you can show that you are a parent or a primary carer. So it may be that you are the biological father, you are the biological mother of this child, and you have care of this child, and most
mm,
of it has to do with EU case law. And quite a few of them have gone up to the Court of Justice. So, whenever the UK courts have not been able to decide on EU law, the cases have always been taken up to the European Court of Justice,
mm,
where they review the circumstances of each case and how the national country can implement EU law to obviously be compatible with their national laws. And so, an example will be the case of Texiera, where, for instance, the primary carer of this child, so she was an EU national who had gone to live in another EU member state. She had her
yeah.
child, she was looking after her child, and then she couldn't work anymore. She had to be at home with the child. The child started school, and she couldn't apply for a right to reside because she was not working. And because she was
Mm,
not working, she she was stuck. And this
mm,
case went all the way up to the appeal courts, and then it had to be taken to the European Court of Justice, where they said they do understand that this lady is not working. However, she used to work and she now has a child. And unfortunately, if this child has to leave and can no longer be in education, then of course, it would mean that because the parent was not able to stay, this child will also have to leave the country. And
mm,
the European Court of Justice said that cannot be right because under our EU directives and regulations, there is that free movement of EU nationals, and that includes their family members, which includes their children. And so, because she has worked within this member state and she has a child who is also an EU national, she should be able to derive her right to reside in that
Mm,
member state because of her child. And that was the good news for her, because now she had the European Court of Justice to look up to be on her side, and she was able to regularize her stay that way. So
mm,
primary carers are usually the parents of the child. It may be that the parents, the biological parents, may not be alive or may not be able to take care of the child. That is when there will be parents, or I mean, there'll be grandparents or other people who are family members who would have to care for this child. But in most case laws, it was the parents or the carer of the children that were able to derive their rights from these children.
mm, mm. What requirements are to be satisfied when making such an application?
So when it comes to deriving your rights from an EU national child, prior to the Appendix EU or the EU settlement scheme, we had cases such as Chen and Ibrahimi, which looked at the way that, for instance, a non-EU national, so it could be a Nigerian national or a Ghanaian national, who
Mm,
was trying to say that they are deriving their rights from that EU child because of the fact that this EU child has the right to move and reside in other countries. And so, under the case of Chen, for instance, you would have a parent who was a primary carer say that they are living with this child who is an EU national. And
mhm,
because this child is being taken care of by their mother or their father, who is the non EU national, this person is saying they are self sufficient. So, self sufficient means that they are not relying on the state or they are not relying on the welfare benefits. And they are saying they also have comprehensive sickness insurance to be
mm,
able to care for themselves when um, they fall ill or any of that. And if they were to leave, that would also mean that the child would have to leave the UK as well, because there will be no other person to look after this child. And
mm,
so, under that principle or the case of Chen, it's a very, should I say, true story of how other country nationals get stuck when a lot of the time the national laws are not on their side. And
that's right.
yeah, the Chen case was to do with a Chinese national who had come to live here. Her husband was working in China, very successful business they had. But because she had a second child and there was the one child policy in China, she didn't want
Mm,
her child to be aborted. She just wanted to have her child. And so she decided to go and live in Northern Ireland, where she had her second child. So the child, during that time when Ireland was very generous with their citizenship. So at the
mm,
time, if you were born in Ireland or in Northern Ireland, you will be given Irish citizenship. I don't think it is the case now, but she was able to have her child, her second child, and she obviously had the child be granted Irish citizenship. So once the child was given Irish citizenship, she then again decided to move to the UK because I think her husband had more of the business transactions in the UK rather than in Northern Ireland. Yes. So she went on to be in the UK, And unfortunately, she could not make an application on the basis of her child because her child had Irish citizenship. She had to go up all the way to the European Court of Justice for them
Mm-hmm.
to say that even the child who is little, she had just given birth to this child, the child hadn't started school. Even that child, him or herself, had a right to move from one member
Mm-hmm.
state to the other. And
Yeah.
because she was self sufficient, which means she didn't have to rely on the public benefits, she could make an application to reside in the UK because she was deriving her right from this child. And
Mhm.
therefore, this child um, was able to show by the fact that her mother or the fact that the mother was self-sufficient, she didn't need the public purse, and she also could show that she had comprehensive sickness insurance. And so the basis for the application was that she was to show that she was the main primary carer of this child, that she was self sufficient, and that if she were to leave this country or she were to have left the UK, that meant that the child would have had to leave the UK as well. So that was one of the breakthrough cases for
Mm,
parents who were looking to have their children here in the UK, but couldn't apply under our normal immigration rules because the child
mm,
didn't have British citizenship, for example.
mm,
Yeah.
mm, mm. Okay. So, can a primary carer who previously had residence card as a family member of an EU national switch to applying for derivative rights? Oh,
Yes, I think that um, our Appendix EU makes things a lot more easier. I think
mm,
because of the fact that they had to be generous in their withdrawal agreement,
mm,
the UK government has decided that if you were previously eligible to make an application as a family member and you could no longer rely on that family member, but you have a different route under the appendix which you can apply, then you
mm,
can continue to have residence in the UK based on that family member. So it could be that you previously had the right to remain here as a family member and you were a spouse to an EU national and your EU national spouse has passed away, for instance, and because
mm,
that spouse has passed away, your children who are EU nationals also reside here in the UK. And so it will be a
mm,
sad thing for them to say that because your spouse has passed away, you can no longer live in the UK. So, if
mm,
your children, for instance, have EU nationality or citizenship, then it is for you to say that, yes, I have EU national children, either that they are in education and so I am applying to remain here with them so that they can continue in education, or it could be that they are very young and you want
mm,
to be able to say you are deriving your rights from them. You don't need the public purse. You work and you are
mm,
able to look after yourselves. And if the need be, you have comprehensive sickness insurance to be able to look after yourselves. And so they should continue to give you that right or residence permit to live here in the UK. So, yes, it is possible.
Okay. All right. Nana has a question. But before then, he's, commending us for such a wonderful educational program. He always tunes in every Saturday, and is encouraging us to keep up the good work. Thank you, Nana. Nana said, I have two children who are Dutch nationals, and they were born in the UK and have lived here since. The first is 8 years old, and the second is 6 years old. Their mother decided to leave the UK in March 2020 and has since not returned. I applied for the children and they were granted indefinite leave to remain. I have residence card as a family member of an EU national, which is due to expire. Can I apply using my children?
So he has said that he's got children that are Dutch nationals.
Hmm?
He's lived here with these children since they were born.
Yeah.
Unfortunately, the mother has decided to go away and she's left him with the children basically. Um,
Lucky mom, isn't it?
I know, right?
I thought
I,
it should be the other way around.
trust me, you will meet some women and you will think, really, are you a mother?
It's very rare.
Yes, but it happens with the job that I do. The things
Mm,
that people hardly see and hear of, that's what we see and hear of. So it is that kind of thing. It's sad, but it's unfortunate that the mother has just, should I say, abandoned the children. And where I come from, back in Africa, that happens a lot. Yes. So
mm,
it's unfortunate, but it happens when I feel that um they feel they can't bear it anymore,
it's
or
true.
they want a way out, and
The
they
way out.
can't,
Yeah.
yeah, they can't take it anymore, and sometimes they just do what we call the worst thing, but to them is it's okay because
Way
they have
out.
somebody to tell, yeah, to take care of them. So as
Yeah.
long as they have someone to take care of them, then that's fine.
Mm,
So in his case, I think that because his wife has left the country, when you look at the case of Ibrahim, where I was
mm,
saying that the mother had to rely on her EU national children. The father of the children had left her, and she was the only primary carer of the children. The children were in school, and she
mm,
had to take care of these children. And so it was the case that when they lived together as a family, the husband was working here in the UK. And so he had worked here for some time before leaving
mm.
her and the children in the UK. So this is
Okay.
very similar in that case because I'm sure the children's mother may have worked here for some time before leaving the UK. It may even be that because the children have lived here for more than 5 years, that she
Mm,
also had permanent residence because prior to the UK leaving the EU,
mm,
people like EU nationals had the right to permanent residence. So if you could show that you had lived in the UK and you had worked here for a continuous period of 5 years, then
mm.
it is said that you would have attained that right to permanent residence. So it could be
Okay.
that she had already attained that right. And so these children as well also have permanent residence, or they have indefinite leave to remain under the EU settlement scheme, as he said.
Mm,
Once, of course, he makes the application, he should be able to show that the mother lived here with him and the children. She worked, or she has that permanent residence, and the children are in education. So when we say the children are in education, it means that the children are either in reception or higher. Unfortunately, they do not consider necessary to be in education because the compulsory age of school here in the UK starts from the age of 4.
mm.
So
Oh, yeah.
once you are in reception, then it is said that you are in education. And if he can show that the children are his children, he's their primary carer, he looks after them, he is the one that takes them to school and does everything for them, yes, he can make the application, because if he is not to be in the country, there will be no
Mm,
one else to look after them. And that would mean that they too cannot continue um, to go to school or to remain in education, and they would have
mm,
to leave the UK. So
mm,
he can make the application, showing that yes, he previously had that spousal residence card, but
mm,
unfortunately, his wife has abandoned them. He now has to look after these children. So instead of continuing to make the application as the spouse of this person who has left, because he says that she left
mm,
last year, is it? And so if um, during that time he can't show that they have been together for that 5 year period and he's been looking after these children, he can
mm,
show that he has now derived his right from these children. The EU national was working here in the UK. The children
mm,
are in education. And if he
mm,
is not to be here, the children can no longer be in education or remain here in the UK. So
mm.
once he's able to show all of that, he can make the application, because Appendix EU allows for those who are making an application for indefinite leave to remain to combine those different routes to be able to apply for indefinite leave to remain in the UK.
Okay. All right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. This program is to educate you on, your rights. We focusing mainly on immigration. If you have any questions or queries, you can do so now on all our social media handles. This is free consultation because after today, when you walk into Lawyer Eunice's office, you have to pay for consultation fees. Am I right, Lawyer Eunice?
Of course, you are.
Yes. So grab this opportunity and send in all your questions on our Facebook, YouTube, where we are transmitting live, and Lawyer Eunice will happily answer all your questions. May I also remind you that today's topic is how to apply under the EU settlement scheme so that you can continue to live with your EU citizen children in the UK. So that is what we've been discussing
Mm.
with Lawyer Eunice. Lawyer Eunice is one of the solicitors and partners at BWF Solicitors, one of the top three law firms in London. They've won so many accolades and awards. And some of their specialities, because of time, I cannot list everything, but just to give you just a few specialities that they deal in: immigration and nationality, Ghana law and practice, family law, dispute resolution. So if what I've mentioned right now is something that you have any issues in that area, look nowhere else. Call BWF Solicitors, and Lawyer Eunice and her team will be very glad to and happy to attend to you. Right, Lawyer Eunice. This next viewer's question is a very sad one. She's asked to remain anonymous. She said, I had my daughter in December 2019, and I lived together with her father until he passed away last year. It was a very difficult, period for her at first, but she was very fortunate to have friends who have been supporting her regularly, uh, giving her financial support. She's now asking, what does she need to make the application?
Okay, so In terms of making a derivative right application, I know it's very difficult to lose a close family member. It makes things all the much harder. Um, it's not easy, but I think that when it comes to situations like this, women are built to literally carry on. Um, I feel that most women have a inner strength and they are able to do things that most men may find even difficult. So I really would like to say that in a situation like this, she's
Mm,
done well and she should keep strong. Where she would be making the application would be to say that because this child is an EU national child, so um, hoping that her husband would have worked for a while. Usually, under our past regulation 2016, if you've
mm,
lost a loved one and you are able to show that this EU national spouse was working here in the UK for at least a year before
mm,
he passed away, you would be able to retain your right as a family member of
mm,
that EU national. So she may be able to make that application to retain her right, or
mm,
she could choose to make the application based on the child. Um, to retain her right means that she will be given that 5 year residence permit, and
mm,
to derive her right from her child would be a 5 year residence permit. If, of course, she had been here with her husband longer before they had their child in 2019, and
mm,
of course, the child is um, a child who is just over 2 years old. If she was saying that she had previously lived with this partner or spouse and they had made an application for residence card, which was almost about to end, I would have said, okay, then she can put in an application for indefinite leave to remain. But
okay.
that has not been mentioned. So I'm assuming this is her first application. And if
Application.
this Yes, if this is her first application, that means she's applying for leave to remain under the EU settlement scheme. So,
Mm,
under Appendix EU of our immigration rules, when you're applying for such a leave, which is limited leave or pre settled status, you should be able to show that you are either an EU national or a family member of an EU national who has derived their right from um, this child, this EU national child. In her
mm,
case, because the child is just over two, he is not in education or she is not in education. And so
mm,
she will have to show that she is self sufficient. And she said that there are people that are supporting her financially, which is a good thing. So she is being supported financially, maybe because she's not able to go back to work yet. If she has a part time job, that's even better. So if she's able to show that she's self sufficient and she is now holding a comprehensive sickness insurance for the both of them, then she can make the application for that pre-settled status or limited to remain
mm,
here in the UK. If she was saying that she had prior to this been given residence card as the spouse of an EU national, and she was saying that this route or the permit was almost coming to an end, then she may look to make the application on the fact that this spouse is now passed away, and she would now like to apply for indefinite leave to remain since he passed away. So, depending on more details that will be given, I think there might be a solution or a
Okay.
way out in terms of that. Yeah.
Mm, mm. Okay. All right. Can one apply for benefits if they are granted limited leave to remain under the EU's Testament King or units?
So I know that this is a very hot topic because under Appendix FM of our immigration rules,
Mm,
when a person is given that leave to remain for 2.5 years, they would usually put no recourse to public funds, and you know
yeah.
that that
Yes.
person is not going to be given a right to any public fund
Yeah.
whatsoever. And it is the same with those who derive their right from the children.
Mm,
If it were an EU national and they had children, usually they will be afforded the same right just as a British national. But in
okay.
this case, we have this primary carer who is saying that they do everything for this child. And so, unfortunately, as the law stands, you will not be able to, get access to these benefits, even though, for instance, the child may have lived here for a period of, let's say, 5 years and probably gotten indefinite leave to remain.
Yeah.
Because you, as the primary carer, do not have indefinite leave to remain, you would
Mm-hmm.
have to still keep on providing for them to be able to derive your right from these children. So,
Mm,
unfortunately, you wouldn't be given the access to public funds such as child benefits and the working tax credits and the rest of it, just because you are deriving your right from this child and you are a non EU national yourself. And so, unfortunately, you wouldn't have access to these public funds. Like I said, if you were an EU national yourself, then yes, of course, you would have access to these uh, public funds. But unfortunately, it is not so for those primary carers who are deriving their rights from this child or from their EU national children.
so can there be an exception when probably the parent or the carer has lost their job? How do they take care of the child? Are there any
So
exceptional
So
cases?
I always ask myself this because when it comes to, let's say, even parents who have autistic children or disabled children and they
Yeah.
have to stay at
Mm,
home to look
yes,
after
exactly.
that
Exactly.
child, how then would they be able to look after this child and work at the same time? And
Mm,
that is the predicament that we find ourselves in. In this person's case, is a good thing that um she was saying that her family and friends support her. Can
yeah.
you imagine if you didn't have that supportive network where you could
Mhm.
call on somebody to give you £20 or £50 here and there, or they would generously give to you because they know your situation? If you didn't
Mm,
have that network, that would mean that you and your child will have to go hungry. But I believe that when we look at our UK system, the good
mm,
thing about our welfare system is that regardless of the status that you have, when it comes to children that need essential accommodation or
yeah.
have
Yeah.
needs that need to be taken care of, if you are bold and strong enough to keep knocking on their door, they
Mm,
do have to do something for that child. And
okay.
we have the Children's Act, which gives local authorities
Mm,
that authority or that obligation to look after children who are in need. So, regardless of your immigration status, they
mm,
will look after that child who is in need of, let's say, accommodation or food or It could be
Mm,
that there are essential needs that they do not have, and if they do not provide these to their parents or to that child, unfortunately, the child will not make it. And so, um, maybe when the situation has become so dire, then you can run to the local council and say, I don't know how I'm going to survive with this child if we don't get the support. So
but
that will be an
mm,
exceptional circumstance.
uh, but then the carer might be thinking when it's time for me to renew, is
Mm.
going to flag up that you seek help from
From
the
the from the
city.
local authority. It is one of those things where once you have taken that support, because it was not for you, it was for the child. So
Exactly.
that's why it's called a child in need support system. So
Oh,
yes, they would know that you have had access to that support,
mhm.
and that doesn't affect your immigration status in any way, because of the fact that that child was in need and that child needed the support, and that is why you needed to go to the home office, I mean to the local authority, to get that support. Otherwise that child may not have even seen the next year, for instance. So
Okay.
that would not affect a parent's immigration status in any way.
Okay. So when it gets to that point, you will have to put in the reason why
You had
got
access.
access
Yes.
to.
Yeah.
Oh,
And then I know that um most times, if you were given some form of access, then some caseworkers will even suggest, why don't you um apply under the 2.5 year route. So if you are
oh,
saying that you are a parent looking after a child who um is probably British, for instance,
mm,
then why don't you apply under our family roots, like in the case of Akisenya, where she was a parent with derivative rights, and then she wanted access to benefits, so she just switched to the 2.5 year route.
2.5 year route,
And,
yeah.
and now that we have what do you call it? The fact that the Kisenya case is now saying, yes, she has been given 2.5 years, she had access to benefits. Now she can go back to derivative rights and apply for
Mm,
indefinite leave. Once she has
mm,
indefinite leave, she will still have access to
you have
benefits. So
access, yeah.
why
Yeah.
not?
Yeah.
So yes, I mean this issue about benefits, I know it is something that is a thorny thing when it comes to
Yeah.
derivative,
Yeah.
because you can't easily access those benefits. But
Mm,
where the situation is dire, the local authority has to step in. Yeah.
okay. Okay. Well, on that note, I think time is up. And also, that was the last question. Yeah. Probably, Eunice, quickly round up for us and also leave your details. I've got some messages asking for your address, office address. So
Okay.
please round up for us. Just give
Okay.
us summary and your details, please.
Okay. So, as I was saying earlier, there are parents who may have come into the UK before the 31st of December 2020, when the EU rights and treaties and laws no longer played a role in our UK immigration laws. And so, if you are such a parent of an EU national child and you are looking to apply for your leave in the UK, so it may be that you are not an EU national yourself, you are a primary carer of that EU national child, and you want to be able to apply to reside here in the UK, you can do so if you are saying that the child is in education and the EU national, prior to that date of the 31st of December 2020, was living here with you had worked here in the UK for some time until their passing away, or until they left the UK, or until they decided to abandon you and the children,
Mm,
or even that a court order says that you are the main primary carer of that child and the child should reside with you, you can show that, yes, I am a primary carer of this child. That
mm,
EU national was working here in the UK. I am able to care for this child. And if I do not care for this child, or if I am to leave the UK, this child will also have to leave the UK as well.
mm,
Once you have been able to show these things, you can put in the application for derivative right. Or it could be that you have a young child and the child is not yet in school. As long as you are able to show that you are self sufficient, you are not on public benefits, and you
mm,
have comprehensive sickness insurance, then
mm.
you can go ahead and also make this application. If
Okay.
the child, for instance, has indefinite leave to remain or permanent residence, then you wouldn't even have to show that this child has comprehensive sickness insurance because they have settled status here in the UK. So it
Mm,
could be that there is no EU national parent, but the child himself or herself was an EU national because of the fact that they were born in an EU national country. So if that is the case and there was no EU national working in the UK, you can rely or derive your rights from this child and make the application to reside here here in the UK. Obviously, we do not just deal with immigration issues, we also look at other issues such as non molestation orders, child arrangement orders, and other legal matters. So do not hesitate to contact us when you need that support in terms of your questions being answered, or you do need legal representation at court, or to do with an application or any of that. So, as Vicky said, I am one of the solicitors at BWF Solicitors. We are situated in London. Our address is the fourth floor of Anna House, 214 to 218, Tottenham High Road, London, and the postcode is N154NP. So N154NP. Our telephone number is 0208 493 7340. So it's 0208 493 7340. And we are usually open from Monday to Friday, 9:30 a.m. to 6 p.m. My contact number out of office hours is 075 3581 3910. So I hope that this show has been helpful to somebody, and
okay.
definitely we'll see each other later on next week.
Yeah, 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 yeah. So on that note, we've come to the end of this program. Those of you who just joined us towards the end of the program, I've got good news for you. This program will be recorded and should be available a few minutes after the show on our YouTube, Facebook, handles at BWF Solicitors, at BWF Solicitors. You get the show from the beginning to the end. You sit down, relax, and whilst watching this, if there's anything that you want to ask Lawyer Eunice and her team, she's giving you her details and phone number. Give her a call, and she'll book you in to come and see her. You know, see how best she can help you. So take good care of yourself until we meet next week. Take care. God bless. Bye.
Bye.